Greetings, honorary members of the Parliamentary Working Group on Land Reform. I am Teo Jun Tao. Thank you for inviting me here today. It is my honor to deliver a video presentation regarding legal framework for land ownership and registration, and whether it remains fit for the purpose in achieving the goals of accessibility, efficiency, and transparency in the 21st century. In this video, I will mainly provide my insight in three issues. The first being the mirror principle and how it operates alongside the other two principles. Secondly, the extent to which the mirror principle is upheld in practice. And finally, suggestions for the reform of the Land Registration Act 2002. Okay. Now, you may ask, what is the difference between an unregistered and registered land? Well, an unregistered land is land that has not been entered into the land register, meaning its title cannot be proved by the land register. Title can only be established through title deeds, or looking at the land charge registry for any registered interest, or by inspecting the land. Meanwhile, a registered land is land that has been registered in the land register. The register will contain the ownership title and relevant rights affecting the land. This provides better security of title as the person can prove ownership easily as compared to unregistered land. Alright, so now there are three fundamental principles underlying the system of registered land, which are the mirror principle, curtain principle, and the insurance principle. I'll start with the most important one and our main focus today, which is the mirror principle. The principle states that the land register should fully reflect ownership title as well as the relevant interests affecting the land accurately. The register acts sort of like a mirror. In a mirror, you can see your own reflection. Now think of this as a mirror of the land, which is a clear reflection of everything about the land. Therefore, prospective buyers or anyone with an interest in the land can simply rely on the register to check for title instead of conducting difficult investigations, as was the case with unregistered land. The mirror principle relies on registration of all rights, so that the register can represent a full picture of the title all the time. However, it does not operate fully in the system of registered land, as there are rights which are binding on the land without needing to be entered on the register. They are known as interests that override. We will dive deeper into this topic later. The next principle is the curtain principle, which asserts that a purchaser of land need not concern themselves with matters beyond the register, as certain equitable interests, particularly those arising under a trust, are kept hidden behind the curtain. This means the purchaser is only required to consider the interest recorded on the register and need not investigate any equitable interests held under a trust. The curtain principle may seem slightly at odds to the mirror principle as it hides several equitable interests behind a curtain, not offering full transparency. However, the doctrine of overreaching, which is mentioned in Section 2 and 27 of the Laws of Property Act 1925, can resolve this contradiction to some extent. The effect of overreaching is to cause the beneficiary's equitable interest to be transferred to the purchase money. As a result, the purchaser is able to take the land free of those interests and not be bound by them. Despite this, some equitable interests cannot be overreached. As mentioned in Section 2, Subsection 3 of the Laws of Property Act 1925, the effect of this is that it becomes an overriding interest and the purchaser will be bound by it. An example will be the case of Hodgson's against Marks, where an elderly woman transferred her house to her lodger in trust, but he sold it without her knowledge. The court held her beneficial interest could not be overreached, and was an overriding interest as there was only a sole trustee and she was in actual occupation of the land at the time. Lastly, the insurance principles provides that the state guarantees the accuracy of the register, providing rectification of mistakes, as well as compensating anyone who suffers a loss from an error in the register through a statutory indemnity system. This principle acts as a safety net for the mirror principle during mistakes, reinforcing the overall reliability of the registration system. The mirror principle operates alongside the curtain and insurance principle to ensure the transparency, effectiveness, and the reliability of land registration. Now, we will be assessing the extent to which the mirror principle is upheld in practice. In practice, the mirror principle does not operate fully in the system of registered land. That is because in cases involving the existence of interests that override, the mirror principles fall short. The reason for this is because purchasers of registered land might be bound by certain interests that are not visible on the register. Hence, interests that override may be known as a crack in the mirror, directly contradicting the mirror principle's idea of a complete and conclusive record. Despite this, some scholars, such as Martin Dixon, argues that there is nothing inherently wrong with some rights not being registered. He highlights that policy considerations may justify the protection of certain non-registrable rights, especially those without legal knowledge or means to register but have a legitimate interest in the land, such as spouses or cohabitees. The Land Registration Act 2002 had reduced the number of circumstances when an unregistered interest could bind someone, such as removing the previous rule that regardless of registration, an interest will bind a landowner who knew of it. Its list of overriding interests also omitted some that had been featured under the 1925 Act, reducing the number of possible circumstances. The main types of interest that override can be found from section Schedule 3 of the 2002 Act. The first will be interest of persons in actual occupation. A person arguing for such an interest will override a registered disposition if they are in actual occupation of the land at the time of the transfer, and their occupation will be obvious on a reasonably careful inspection of the land, or if the transferee had actual knowledge of the interest. However, if the person in occupation failed to disclose the interest when they could reasonably have been expected to do so, the interest will not override. Here, we will look at some cases. The first is Abbey National Building Society against Can. In this case, it was held that a mother's equitable interest from contributing to the purchase price could not override the lender's mortgage because her occupation began just minutes before completion. Both the right and the occupation must exist at the same time. In this case, at the time of the acquisition of the property by the purchaser. Another case is William and Glyn's Bank against Boland. In this case, the wife had an equitable interest in the home through her financial contributions and was living there at the time her husband mortgaged the property without her knowledge. The court held that her interest could override the bank's claim because she was in actual occupation. It was confirmed that actual occupation is a question of fact, not law. The next type of interest that override is short leases. These leases must be legal leases, as stipulated in Section 52 of the LPA 1925, and the term of lease must not exceed 7 years. The reason for allowing this short interest to override is because they are considered too minor to justify registration, but occupiers still deserve protection. It should also be noted that leases that do not qualify as overriding interest may actually still qualify as actual occupation. Next up, we have legal easements, meaning those that are created by deed or either implication and prescription. They need not be registered but must fulfill some conditions. They should be known to the buyer and are obvious on a reasonably careful inspection, or have been used within the past year. The reason these are allowed is to protect long-standing rights like rights of way, which aren't registered but are visible or known. It will also be quite impractical to register all of them, as some are quite small and they are all over the country actually. Okay, another issue that undermines the mirror principle is the number of unregistered lands in the country. Despite land registration having gone up as compared to the past, around 10% of lands around the UK still remains unregistered. Unregistered land is a problem for the mirror principle as it does not apply to it. In unregistered land, ownership and interest are proven through title deeds, not a government-maintained register. This makes it much harder for buyers to verify ownership and interest, creating uncertainty and defeating the fundamental purpose of the mirror principle, which is transparency. Aside from that, unregistered land keeps the process reliant on traditional paper-based systems, which is slow and inefficient. This defeats the purpose of the mirror principle to streamline and modernize conveyancing. Alright, now I will be proposing some reforms in order to improve the Land Registration Act 2002. First of all, we should limit interests that override. Although these interests may hinder the mirror principle and create uncertainty, I actually agree with Barbara Boger's view that it should not be abolished as it serves to protect vulnerable parties. However, the list of overriding interests should be kept to a bare minimum and only be allowed where registration is impractical or unreasonable. For instance, rights arising from actual occupation should continue to be recognized in limited and clearly defined circumstances, especially when individuals may lack the knowledge or ability to formally register their interests. At the same time, efforts should be made to promote registration of other rights that are capable of being registered, especially as the system moves towards e-conveyancing. An example being leases that are less than 7 years and certain easements. We need to find a balance between ensuring the reliability and transparency of the land register while protecting those that are vulnerable. The balance can eventually be reached as our legislation develops and the public gets more educated. The next reform I propose is to fully implement and improve the e-conveyancing system. Despite e-conveyancing being introduced in the 2002 Act and having underwent rapid development, it still hasn't been fully implemented in the industry, as some aspects are still done by hand. The reason it hasn't been fully embraced is due to a few reasons, such as the fact that people have a hard time getting used to new things, as well as fears of cybersecurity breach. A solution to improve the e-conveyancing system is to construct a better regulatory framework which provides better security to ensure that people trust it. With the emergence and development of AI, there's no better time to do that than now. Alongside with improving its regulatory framework, the system should undergo improvements to make it simpler to use. As the system becomes simpler to use, its usage will definitely increase and efficiency will go up. E-conveyancing is a step towards modernizing conveyancing. It's high time that it was improved and fully implemented for its benefits. Next, we should find a way to register all land in the UK. Around 10% of land in the UK still remains unregistered. A majority of those unregistered lands are due to there being no transfers on the land and the landowners not knowing about land registration and its benefits. A way this can be solved is by launching a campaign which promotes land registration and its benefits, and pairing it with financial incentives such as reduction of fees. If this doesn't increase the number of registered lands, the government can also introduce compulsory registration of title after a fixed grace period, even when no transfers has occurred. If all lands in the UK become registered, it will greatly enhance the reliability and efficiency of the land registration system as it ensures that all land rights are reflected in the register and discoverable by third parties. Lastly, an area that can undergo reform is broader indemnity regarding rectification of mistake. The definition of a mistake is called into question in situations where an innocent original proprietor, okay, let's call him Party A, loses out due to the fraudulent actions of a third party, Party B, who then transfer the land to another innocent party, Party C. In these types of scenarios, is the subsequent action of Party C acquiring land a mistake? According to Emma Lees, it is not a mistake as a title is guaranteed by registration, meaning B had the power to transfer the interest to C, even if B's initial registration was based on a void transaction. This can be seen in the case of Barclays Bank against Guy, where the original proprietor was not entitled to an indemnity despite their title being burdened with a massive charge, because the subsequent charges registration was not considered a mistake. There are also some cases which seem inconclusive about what is the definition of a mistake. Therefore, I believe that the solution to this problem is to establish a broader scope of indemnity. The original proprietor A should be entitled to an indemnity for their loss, even if the register is not rectified to remove C's interest. This helps ensure the validity of the insurance principle by compensating those that suffer losses due to mistake, as well as fulfilling the goal of a conclusive register by ensuring the concept of title by registration. If these changes are made, people have greater confidence in the land register and the law will become much fairer. In conclusion, while the Land Registration Act 2002 has significantly modernized land ownership and conveyancing in the UK, there are still key areas where reform is necessary to fully realize its goals of accessibility, efficiency, and transparency. The mirror principle, true central to the system, is currently undermined by several problems. By undergoing key reforms, we can move closer to a system that is fairer, more secure, and fit for the 21st century. Alright, that concludes my sharing for today. It has been an honor to be able to present this video. Thank you for your time.